Brian Walshe walked into court for an evaluation to determine if he's competent to stand trial. The judge said yes, the trial will start on a very short schedule, but there are a lot of other issues hovering in this case in this episode.
You lost. And you know what you did.
As we know, there are a lot of parallels, at least in law enforcement, from the Karen Reed trial to the Brian Walshe matter. I'm attorney Andrew Myers. Joining me for this edition of About the Law, California attorney Yolie Medina. How are you, Yoli?
I am fine. We're having some rain here, but otherwise we're okay.
Well, this is the first day we've had this week that it didn't rain, at least a little bit, and so, we're holding our breath. We need the rain. People always say, we need the rain, don't we?
Yeah, right.
So I know we both watched this hearing. I was not all that surprised that Brian Walshe was found competent. We'll get into that in a minute. But I was surprised that they're keeping this trial on a very short deadline. Were you surprised by any of that?
Yeah, Monday they start.
Monday.
Yeah,
we're dropping this episode on a Saturday. 2 days from then, they're going to start. Well, the first thing is a final pretrial, which I guess for non-attorneys might not be that interesting. But then again, in this case, it may very well be quite interesting.
Yeah. And at the end of I watched, after the sidebar, they mentioned something about a brief. They were going to discuss a briefing, and I don't know what briefing that was. I don't know if you heard that, but we can go over it if you play the video.
Well, yeah, let's catch that and a couple of other things. There is going to be a final pretrial, and the pretrial memo has a lot of issues just swirling around. And, of course, this is the case, not the least of which is this is the case where Ana Walshe disappeared New Year's Eve, December 2022, January 2023, she disappeared. And then shortly thereafter, Brian Walshe is said to have made a bunch of very incriminating searches on his 6-year-old son's iPad or whatever device he had.
Yeah.
And we've done episodes on that. I'll link that down below. You should watch it because it's unbelievable. But that was partially decided already. The court's going to let that in, but that's not the only issue. Okay, let's go. Let's get into it. Here is the Norfolk County Superior Court in Dedham, Massachusetts. There was a little bit of drama until Mr. Walshe walked in the courtroom. He's walking into the courtroom. We didn't know what to expect, but he's well coiffed, wearing a suit and tie. The man was shanked in jail several months ago. There's no sign of that. And everybody's wondering, now what? Here he is. We've been waiting. The thing was about 2 hours and 25 minutes late. He's speaking to the defense attorney who works for his defense attorney, Larry Tipton. And so, obviously, they're having a conversation. They're having a sidebar. We all know about sidebars in Norfolk County, don't we?
Oh, my God. Yes.
This was Judge Frenier who is presided. They've had judges switch a little bit in this case, but this was Judge Frenier who was going to be the trial attorney. This is the big courtroom. This isn't the little teeny courtroom in which Karen Reed was tried. Not that that's overly relevant to our listeners. Okay, they return from the sidebar. There's Larry Tipton, Brian Walshe's defense attorney, leaning over, probably telling him what has just transpired. The report is back from Bridgewater State Hospital, where Brian Walshe had stayed for the last 40 days. And looks like they are ready to actually start.
All right. So welcome, as I said, to counsel, and welcome to Mr. Walshe. I have a few things on my agenda. The first one, which is over here, is the competence. I've now received a report from Bridgewater State Hospital, a comprehensive report from Dr. Ryan. And in that report, Dr. Ryan concludes that the defendant is competent and ready to stand trial.
So that was the big issue that we were all waiting for. We thought that this entire hearing was going to be, on competency. Is Mr. Walshe competent to stand trial? And it's a very important concept because a defendant under the Constitution has a right to participate actively in his trial. And if he's incompetent, he can't stand trial. And so I think a lot of people, myself including, were thinking, well, the report, like a lot of things in the law, might be not as clear as we would like. And so, Attorney Tipton and the prosecution will argue back and forth. And a lot of us thought that was going to be the hearing. We were wrong.
Right. They had other matters.
So that was accepted by the judge right away. And so they figured out, what are we going to do now? And they did figure some other things to do.
Yeah.
So with that finding, which I accept, I had a brief conversation with the side of the bench. What's the defense's position? I just want it on the record, on the public record, with regard to the defendant's competency.
And the audio was awful, as often happens in these things. They don't do this for YouTubers, and they don't. I was surprised that Boston 25, an excellent station, didn't have it mic'd better. But basically what he's saying is, well, that's all right for them, but it's going to be very jarring for Mr. Walsh's routine. He's now been in Bridgewater State Hospital for 40 days. Now he's going to be transported back to the prison, and his routine is going to, he's been in a certain routine for 40 days, and now he's going to have a whole new routine, and it's going to be jarring to him. And, we don't think that's fair. We'd like more time. We don't want the trial to go ahead right away. That's basically, I strained my ears to listen to all this, but that's what I gleaned from it all.
As with any case, and any time, in my experience, the defendant goes to Bridgewater and then is returned to the facility, there's always a transition period. He's been there for 40 days now and has gotten, as I understand, into a routine. And that routine is going to be changed as he moves back to the House of Correction. So understandably, there will be some transition period, and alerting the facility knows this. They deal with this quite regularly. But I understand your intent to alert me to it, and we'll have some time here, I believe, between the time that we're picking a jury in this case and the time. I'm not suggesting that you're not working at that time, but the defendant's role in that is significantly different than it is when we're actually actively engaged in the trial.
So what she's saying is that Mr. Walshe, the defendant, is not actively required for jury selection. Don't know if I agree with that, but it's,
I think he should be there for jury selection.
I don't think the question is whether he's going to be there or not. I think the question is that, during the trial, when there's witness testimony and exhibits and all of that, of course, he'll actively participate. But what she's saying is, even if he's there, it's up to the attorneys with their experience and knowledge, and, they may even have a jury consultant. I don't know. But what she's saying is that his, collaboration isn't as required during jury selection. I don't know if I agree with that, but it's in the judge's discretion.
Yeah, I don't know if I agree with that either, because I think that the defendant has to have, or is allowed to have, input in all aspects of his trial. So I don't know. But in terms of changing the routine, oh my goodness, I see what he's saying, because he's already having some issues, and that doesn't mean he's not competent, but he's already having issues related to getting, shanked in jail. And he's gotten used to a routine where he's in more of a hospital setting, and now he's being transported back to the prison where he was shanked. So, and then the stress of starting a new trial and all of that. But I guess the court has discretion to just keep going.
Yeah, I'm going to correct something I said a minute ago. I said he was going from the Bridgewater State Hospital to the prison. He's not in the prison. He's in the House of Correction. Before people I know, we have some pretty bright commenters, and it's fine. You keep me honest, but I know someone out there will say, Attorney Myers, you said the prison. He's not in prison yet. He hasn't been convicted. He's in the House of Correction. I sit corrected. So now. They talk a little bit before they get into a major issue.
So hopefully that'll give them a nice time to settle back into the House of Correction. But obviously, if at any point you become concerned about that, I know you won't hesitate to raise it with me. All right.
Yeah, the House of Correction, sorry, not prison.
Yeah, that was me. That was my mistake. I know that our commenters love to correct me. I corrected myself this time, folks.
I think I said it too.
Oh, here we go.
So,
The next, so that's what the whole hearing was supposed to be on. The bottom line is that they will start, on Monday, November 17th with the final pre-trial conference. And there are a lot of issues which we'll get to. But then on Tuesday, the 18th, they will start jury selection. And she reserved 2 weeks for jury selection, even though in the second week, the Thursday is Thanksgiving. So that gives them 4 days in the first week and probably 2 days the second week, because although Thanksgiving's on a Thursday, a lot of people leave town the day before.
Right.
A lot of people leave town the day before. So that gives really 1, 2, 3, 4, 5 days, 6 days at best if people are working the day before Thanksgiving. They're certainly not going to work on Thanksgiving, and I would highly doubt that they'll meet on the Friday after Thanksgiving. But you never know. You just never know.
You never know.
let me, and I discussed this with you at this side of the bench as well. I received some edits from the defense to the questionnaire, which I will incorporate into the next version of the draft questionnaire.
They're talking about the questionnaire for the jury. You know, you've got it's not easy. You've got to find jurors, and you can't ask what they call a magic question. You've got to have a questionnaire, and it used to be standard. It's not anymore. You got to have a questionnaire that really does ask penetrating questions to determine who the jurors are, what they, where they come from, what their jobs are, you know, what their biases are, you know, to the extent that the jurors are going to be forthcoming and honest. You know, the questionnaire is always an issue, and it's tailored to the particular case.
Right, and they screen them. You know, they go through the juror questionnaires, and those that they can kick out just based on the questionnaire, they do that, and then they narrow it down that way.
Yeah, and the court said that there are, I think, 109 or just over 100 jurors that are ready to go on the Tuesday when they start the jury selection. So it's a pretty aggressive schedule.
Yeah.
Always a draft until the minute that I finalize it and send it to that pool of jurors. Speaking of that pool of jurors, somewhere on my desk, I have the updated numbers.
Here we go. She's going to correct me.
Who knows what the yield will be, but I expect to take about 70, if I can, 60 to 70 jurors a day. In my experience, it's hard with the questionnaire, even without doing all the copying, to get through more than that number in a day, and there are other cases that are starting on Tuesday. And so if we can accommodate those, we will. We'll have to see what the draw is. The expected number is 105 now for Monday, and we're going to hold those over to Tuesday because, as you know, we're doing the final trial conference on Monday, and then we'll start the empanelment on Tuesday. So it looks like 105, 126, 121, 68 on Thursday, but those people will be pushed and held over till Friday. So we'll have a full group of some number of people to work with in getting a jury next week. And then jurors are here also on Monday and Tuesday of the following week. And I think we're the only game in town. That is, I don't think anybody else is paneling.
Yeah, because that second week is Thanksgiving weekend. So, if they have jurors in 2 days, that would mean, like I said before, they're not going to do it on the Wednesday, the day before Thanksgiving. I wouldn't say. I'm not going to bet because, as you know, I have a bad record in betting on these things. But here we go.
On Monday and Tuesday. Our intent is, if we get a jury during that allotted time, we will start the trial, the substance of the trial, on 12/1, the Monday after the Thanksgiving holiday.
That is a pretty short schedule. So that gives Mr. Walsh 2 weeks to, 3 weeks to get over things. And so, no, 2 weeks. Excuse me. I'll get it straight.
2 weeks.
That gives them 2 weeks. And, if you're starting a major trial, and this is a big case, it's a major case. I know it's been pending for 3 years, but nonetheless, to have that hanging over your head for Thanksgiving, oh, good grief. Enjoy your turkey, guys.
Yeah, and the jurors, I wonder how likely they're going to want to be on a jury, during the holidays. That's always, the last place the juror wants to be.
Yeah, and we're going to look at the pretrial memo where they estimated that the trial could be 3-4 weeks. So, that's Christmas season. That's the entire Christmas season, So how are you supposed to concentrate on, getting your family all set, getting your shopping all set? And kids, if you have kids, they always have recitals and choirs and, all the rest, right?
Yeah. Yeah.
So, I mean, ay.
Everybody on board with that schedule.
They all said yeah, or shook their heads yeah. They're all on board with that schedule.
Let me,
Surprises me. But, justice.
Address, and then once I do this, I'll certainly turn it over to you. We're going to have our formal, really today's purpose was to address the competency. But to the extent that I could pick off issues that aren't technically motions in limine, but other important motions to the parties, I focused on those today. And I am prepared now to make a ruling on the change of venue.
Drum roll, please, because this has been pending. A lot of people said, look, there's been so much publicity, in greater Boston, and there has been. This was a huge story when it broke. New Year's Day and that first week of 2023, it just was an incredible story. And, I thought that the motion to change venue made a lot of good arguments. And I think you and I both agreed, fat chance. But the drum roll, please. And here is the court's ruling. And this was the real meat of this hearing.
Paper. That's paper number 219. And I'm going to read that into the record now.
So she's reading her ruling. I didn't see that it had been on the docket. It may well be by the time we drop this episode, but this was not on the docket. She read it for everyone.
Yeah, right. It wasn't.
Yeah. Because I checked before we go on. I checked, and I also checked before we went on. The Karen Reed motion to add third parties is due any day now. So I checked before we went on to see if that was ready to go. Not quite yet.
Mr. Walsh has moved for a change of venue on the grounds of extensive and prejudicial pretrial publicity that he asserts has tainted the jury pool so as to deprive him of his right to a fair trial by impartial jury. Alternatively, the defendant seeks an order that prospective jurors be selected from outside of Norfolk County. In support of his motion, the defendant has submitted evidence of extensive national and local media coverage of the case, beginning on January 6, 2023, after Ana Walshe was reported missing, and continuing till the present day, as well as evidence of social media engagement with this case. After careful consideration of the defendant's motion and the exhibits provided to the court, I'm denying the motion and the request for alternate relief for the following reasons. The court may order a change of venue where there exists, quote, and it exists in the community where there is a prosecution is pending so great a prejudice against the defendant that he may not there obtain a fair and impartial trial.
This is one of those areas, a lot of observers might be saying, you know what, She didn't allow the change of venue. If he is convicted, this will be an appellate issue. Well, yeah, it will be an appellate issue, I'm sure, but this is one of those areas where judges are given a wide grant of latitude.
Right. And like you said before, the area where the jurisdiction, it's very small. And the likelihood of changing the venue isn't going to impact anything in terms of publicity because that area is small.
No, we talked about that before. You're absolutely right. I mean, Massachusetts is a small state. You probably have counties that are bigger than Massachusetts.
Oh, yeah.
And, with cable TV and social media now, I mean, it's almost as though change of venue arguments are just outdated and antiquated. I don't know. It's something that does have to be considered, and I haven't read it because it wasn't posted, but from the sounds of things, Judge Frenier considered everything, looked at the major case law, statutes, and other legal principles, and, gave a well-reasoned decision.
And that cites back to Massachusetts Rule of Criminal Procedure 37 and Commonwealth versus Clark, 432 Mass. 1 at 6, a 2000 case. A judge has substantial discretion to transfer a case to another county based on pretrial publicity. And according to Commonwealth versus Gaynor, 443 Mass. At 245 at 259, pretrial publicity, even even pervasive adverse publicity does not inevitably lead to an unfair trial. A change in the place of a trial should be ordered with caution and only after the defendant has established, based on a, quote, solid foundation of fact, that the pretrial publicity has created presumptive prejudice. And to that I cite to Commonwealth versus Hart, 493 Mass. 130 at 141, and Commonwealth versus Tulin, 460 Mass. At 452, at pinpoint site 462, 463, a 2011 case.
We lawyers always write these sites down. Look at the two assistant prosecutors there to the left side of your screen. We always write these things down, and I always wondered, why do we write these things down? Because the written decision is going to be on the record, and they'll be able to check it out. But I mean, just by habit. Do you do that? I do.
You know what? I used to do that a lot. But like you said, it's usually in the ruling, in the printed ruling that you get. And in California, sometimes they even give you tentative rulings, so you even have it in the tentative ruling. So I used to do that a lot. I kind of stopped in the past few years.
Yeah, I just have that habit. I can't kick. I just write it all down. But obviously the judge wanted to base her decision on some solid rulings, and for a case to be dated 2000, that's seconds ago in terms of the law, because we have cases that go back to the 1700s, and so that's right. Like that's a very current precedent that was set only 25 years ago. That's like 20 seconds ago.
Presumptive prejudice exists only in truly extraordinary circumstances where the trial atmosphere is utterly corrupted by media coverage, and, quote, the entire venire may be presumed prejudiced, regardless of specific voir dire procedures utilized. This standard is only met if the publicity is both extensive and sensational. And to that I cite to Commonwealth versus Who's, 467 Mass. 395, 406, a 2014 case. In assessing whether pretrial publicity precludes a fair trial, the court should consider additional factors such as, quote, the size of the community, the length of time between the peak media coverage and the date of the trial, and whether the news stories contained a confession or smoking gun rather than merely being unkind portrayals of the defendant, end quote.
So the pretrial publicity has to really rise to a level of almost sensationalism. That's not her word, that's mine. But it's got to be something that really ingrains or inflames the public against the defendant. That did happen to a certain degree early on when the media showed Ana Walshe, who I think, objectively speaking, we all have to agree she's an attractive, youngish, middle-aged woman, and he was portrayed as a monster, I've got to say it. And there was a lot of coverage of, he went to Lowe's and bought $450 worth of cleaning supplies. He is alleged to have gone to landfills to dispose of body parts. And so
they found blood and whatnot in the trash that was the DNA of Ana Walshe, right?
Yeah. We can get into that. I have a little article we can take a look at. Yes. So all of this, but it's not enough. It wasn't enough to inflame the passions of the entire jury pool. And I would also contend, having been a reporter and been sent out on the street to talk to people, I would bet you a cup of coffee that you could go out onto the streets of Boston and there are people that don't know anything about this case. I mean, there are a lot of people that just have their head in the sand. They're ostriches and they don't follow the law. So, I mean, they don't follow the news or the law. So,
or they're not into true crime.
Or they're not into true crime. People don't pay attention to current events. They just don't. So I'm not saying there hasn't been a lot of coverage of this case. There has. But a lot of people just don't follow stuff.
And, it's unfortunate if people have already made up their minds in this case because, he does have the presumption of innocence. But, when you have evidence that is being touted in the media, like DNA found in the trash that belonged to Mr. Walsh and Ana Walshe, that's kind of startling. It's like, well, how did that happen? But, he has a presumption of innocence. So,
yeah, people outside the courtroom can have whatever opinion they want. People on social media can say whatever they want. And social media is more and more taking over from the old media. But this judge has an extremely difficult job, and she's trying to balance it right now that, yes, the man you see right there on the left-hand side of your screen in a suit and a collar, he is entitled by law, by the Constitution, by the Declaration of Rights in Massachusetts, which is what we call our Constitution, he has a right to a presumption of innocence. And every juror that walks in there and gets impaneled has to keep an open mind. So that's the tough job that she has right now. And I'll be honest, I wouldn't want to be in her chair right now.
Commonwealth versus Garhut Strider, 82 Mass Appellate Court 500-506, a 2012 case. The defendant here contends that transfer of his case out of Norfolk County for trial is necessary because the nature and extent of the negative pretrial publicity his case has received has encouraged a bias and prejudice against him in this county. Having reviewed the numerous materials submitted in support of the defendant's motion, I conclude that presumptive prejudice has not been shown. Although the media coverage has been extensive and somewhat graphic due to the nature of the crimes charged, it has also been primarily factual, describing the events in question, the charges against the defendant, court proceedings in this case, and the defendant's criminal history. Quote, fact-based publicity, even that which contains references to charges pending against the defendant or a prior criminal record, is not the sort of sensational publicity that would give rise to a presumption of prejudice, end quote. And that's who's at 467 Mass at 407. The publicity in this case peaked in January 2023 when the defendant was charged in connection with the victim's murder and has decreased in frequency over time, undermining a presumption of prejudice. Again, who's at 406 and Tulin at 460 Mass at 465.
I don't know if I would agree with that the publicity peaked in January of 2023 and has waned since then. As a child of the media, I should know the answer to that, but I would bet that his defense attorney, Larry Tipton, did some kind of a study. I know that he did submit some media, newspapers, and transcripts from TV and radio. So I would assume that he did some kind of a study to confirm that look at all the publicity that took place in January 2023 and look how it's gone down since then. So I don't know. I really don't know.
This story in January of 2023 was competing with the Idaho 4. So I paid more attention to the Idaho 4 story than this one. Although I was aware of this case, I didn't follow it as much. So, if I had to compare, I think Idaho 4 got more media attention than this nationally than Mr. Walsh's case.
That comment is really interesting to me. We didn't talk about this at all before we hit the record button today. And I mean, that's interesting to me because, we all were following the Idaho 4 case, but you're 3,000 miles away from Boston. And what was the coverage like of the Brian Walshe case in California?
It was sparse, at least in terms of what I look at. Now, it was on Court TV and all that, all those channels that covered trials and true crime. But in terms of regular media, it was sparse. There was just few in Orange County here where I live and LA County. It was sparse, in my opinion. Idaho 4 was out there more. I mean, that kept even mainstream media, like on Fox News, they kept talking about Idaho 4, and then they would somehow come, like there would be a short story on Brian Walshe and Ana Walshe, but over here it was more Idaho 4.
Idaho 4 was huge. I mean, and I remember just even if you don't watch the news, you'd go to the grocery checkout line and there was People magazine with huge exposés with the pictures of these 4 young people and other publications to the extent that anybody still reads them. And I guess they must because they're still there at the checkout line in the grocery store. That was big. But that's interesting to me that you tell me about what's going on out there in California. Of course, we're going to get back to Judge Frenier because the issue here is the extensive publicity. And I said Boston. Norfolk County kind of rings around Metro West and south of Boston. So we keep saying Boston. I would guess that it's maybe, depending on traffic. Traffic's horrible in that end of town. Traffic's horrible everywhere in Boston, but from the Dedham Courthouse to downtown Boston, I'm going to guess 15, 20 minutes, depending on traffic. So we're talking about what was the effect of the people that live in Norfolk County, and it's a big county. They can bring people in from the other end of it, and will it taint the jury?
Notably, nothing in the defendant's submission addresses whether the pretrial publicity has been more extensive in Norfolk County or the likely number of potential jurors who were actually exposed to the media coverage. Moreover, other factors weigh against a finding of presumptive prejudice. The trial is scheduled to take place nearly 3 years after Ana Walshe was presumed dead, and therefore there has been a substantial amount of time between the initial media coverage and the selection of the jury. Indeed, much more of the recent media coverage is focused on court decisions leading up to trial and the status of the case. Further, the defendant has not shown that there has been any report of a confession by him or any like evidence. See Gerhardt's writer, 82 Mass App Court at 506. And unlike other cases where the small size of the community weighed in favor of a finding of presumptive prejudice, for example, in Nantucket County, given the size of Norfolk County, the defendant has not shown a high likelihood that the entire jury pool would be tainted by the pretrial coverage of this case. To that, the court cites to Commonwealth versus Leahy, 445 Mass, 41 at 493, 494, a 2005 case. Defendant's motion relies heavily on evidence of negative social media posts presuming his guilt. There is, however, no indication that any of the posts were made by or read by Norfolk County residents, and thus they do not present a compelling reason to transfer his case to another county.
I'm not 100% sure about that. Again, as a media student, I should know, but there must be a study that says that somewhere, because that was huge when those, and we did an episode on them previously. Like I said before, we'll put it down in the comment section, but the many posts that Mr. Walsh is said to have, and now there are people that are questioning that, but he is said to have made a bunch of searches on his 6-year-old son's iPad. And there were things like, how long does it take for a body to smell? Best way to decompose, all this stuff. And we'll put it down in the comment section.
Yeah.
But
It is what it is. I mean, if they found that, they found that. And so, but, again, there's a lot of stuff going on in that jurisdiction with police. So I don't know.
Yeah, there is. Remind me to give my final comment about that, but let's finish up the hearing.
In sum, while the defendant has demonstrated that the national and local media have extensively covered his case, he has not demonstrated the, quote, type of emotionally charged, inflammatory, sensationalistic coverage needed to support a presumption of prejudice. End quote. United States versus Angulo, 897 F. 2nd, 1169, 1181, a First Circuit case from 1990.
Gennaro Angulo was spent some time behind bars. He was a major mafia figure in Greater Boston.
Nor has he shown that there exists in this community a prejudice so great that he cannot obtain a fair trial in Norfolk County. Thus, I will not now order a change of venue. Alternately, the defendant has requested that prospective jurors be seated from outside of Norfolk County and trained.
So it was a two-part motion. I know that you understand this, Yoli, but I mean, sometimes I just want to help our viewers understand that there are two things that defense counsel seek and did seek here. One is a change of venue, which says we don't want to try the case here. We want to move the whole thing to another county, Worcester County, anywhere but here. The second argument was, all right, if you're not going to let us move it, what we want is, okay, we'll come to this courthouse every day, but we want the jurors bussed in from somewhere. Bus them in from Worcester, bus them in from Middlesex, bus them in from somewhere else. Mm-hmm. She didn't buy that one.
No.
Such an order ought not be given lightly. Commonwealth versus Aldopoulos at 390 Mass, 438, 448. 1983. The defendant must, quote unquote, fully establish the reason why a foreign jury is, quote, necessary to further the administration of justice. The defendant's motion falls short here. The defendant has not specified in his motion why he cannot obtain a fair trial with jurors from Norfolk County. He has not, for instance, shown that the media or social media coverage has been more widely viewed by prospective Norfolk County jurors as opposed to residents of other counties. That engagement with social media postings about his case has been higher by residents in this county, or particularized his evidentiary support to the residents of Norfolk County in any way. Merely explaining the widespread coverage of this case in the Greater Boston area and providing examples of negative social media posts from unknown users is insufficient to establish the necessity of a foreign jury. Any concerns as to the impartiality of prospective jurors from this county due to pretrial publicity will be addressed by this court with careful and thorough voir dire and is always subject to reconsideration by this court. Accordingly, the defendant's motion for a change of venue or alternate relief is denied without prejudice. The defendant may renew his motion and the court won't hesitate to re-examine its own decision should the impanelment of an impartial jury prove impossible as a result of community prejudice.
I found that part interesting because, she's denying the motion for change of venue and the alternative, but she's saying, I'm doing this without prejudice, which means we're going to go through this impanelment process we talked about in the very beginning, Yoli, 4 days in the first week, 2 or 3 days in the second week. And if we have a hard time finding jurors that both sides find fair and impartial and unbiased. If we have a problem with that, these defense attorneys can bring it up again. So we will see. So it's not a closed. It's a green light for now, but in a way, it's a yellow light that we'll keep our eye on it, and if we can't get a fair jury, bring the issue up. I don't know.
What's unfortunate is because it's the holidays, you might get people saying, "Oh, I can't be fair and impartial," or I can't. I've already made up my mind because they don't want to be on the jury. I hope that doesn't happen.
Yeah, well, so do I, for the interest of judicial economy and moving things forward. But at the same time, I think that courts are reluctant to accept people's, hurry up. I gotta, do other things. They'll extensively ask people questions. Now, if someone has been called to jury and they just gave birth, okay, that's if someone is called and they already have tickets purchased to go visit Aunt Millie who's dying of cancer. Okay, that's the extent to which questions are asked by courts. I've seen it in paneling a jury. So it has to be a good excuse. It can't just be, I have to do my Christmas shopping. No, they're not going to buy that one.
So there's one other matter that I want to address with the lawyers, and that will take place at the side of the bench. But before I do that, are there other matters that it's important for the parties to raise today, recognizing that we are going to have the final trial conference on Monday?
One quick one, Your Honor, was I know that Mr. Tipton had a hearing on 12/9. I didn't know if the court was going to break for that at 2 o'clock.
Oh, well.
I was going to ask.
All right.
Generally speaking, if you're on trial and there is a jury impaneled and sitting for the case, if you have a hearing in another case, generally speaking, depending on the nature of the other case, the trial court with the sitting jury will contact the other court, which is going to be very understanding because they want to have the same reciprocal respect. So the other court will, more often than not, continue it, put it on for another date. 9 times out of 10. I had a case one time where I had been, and it wasn't a jury trial, but it was a trial, now that I'm thinking of it, in one county in Massachusetts. And at the same time, I had a proceeding in New Hampshire in court. And I told both clerks, and both clerks were, very reluctant to let me out of it. And what happened was the New Hampshire judge contacted the Massachusetts judge, where actually, yes, we were impaneling a jury. But, usually when you're doing a jury trial, at least in that particular court, there's other things that go first. There might have been other motions. There might have been other things. There might have been other, matters. And that court told the New Hampshire court, hey, guess what? We will start a little bit later if you promise to put his case on first up there in New Hampshire. And that's what happened. I walked into the New Hampshire court that morning, and they called my case right out of the chute. And so I was out of that court by about 15 minutes after 9 down to the Mass court. And so the courts are willing to work together. That's what I would guess would happen here.
Yes.
Sorry about the extended story. We've gotten chided for telling personal stories.
Oh.
Anything else?
No, that's it.
All right. Anything from the defense other than what we're going to discuss at the side of the bench?
No, and the only other thing is I just want the record to reflect that we object to the court's ruling.
Certainly will.
So, Larry Tipton, Brian Walsh's attorney, just for the record, you want to maintain, an amicable nature in court. Like we ask people to do in our comments section. But he just, for the record, he wants to put an objection to the change of venue ruling and preserve it for appellate review.
Right.
All right, I'll see you at the side of the bench.
And so even the judge understands that. That's not a big issue. And that was it. And so this went on and on and on and on and on. And then at some point, Mr. Walsh was in fact escorted out of the courtroom because that was it.
I will
So that
say
was-
that when he was walked out of court, he looked a little distraught.
Yeah, he did. He did. And, I think my perception would be that, he really would like to have more time. Nobody wants to go to a trial where things don't look good. And I might be wrong, but I don't think things look good for him in this case. He is entitled to a presumption of innocence. But now let's go over the schedule coming up. So they're going to do the final trial conference. A lot of people will probably be watching this after it, but that is just a couple of days after this hearing. That'll be November 17th, a Monday. Then jury impanelment starts November 18th. They hopefully get that done in 2 weeks. 2 weeks, which include the Thanksgiving holiday. Then the actual trial will start on December 1st. That's when the attorneys will make their opening arguments, and the trial will be off and running. So it's been, as the judge pointed out, almost 3 years. It's been almost 3 years, and so Norfolk County is a fairly large county, and so I would, wonder if people that are way down in Canton, which we're very familiar with, and Stoughton, paid as much attention to it, although we're going to have to do it in our next episode. A lot of the police, law enforcement investigators were the same in both the Karen Reed trial and this trial. In fact, Michael Proctor, remember him, the dishonorably discharged Massachusetts State Police officer? Well, he was the lead investigator in both cases. And remember how in Karen Reed's second trial, they kind of sort of didn't even mention, they tried to not even mention his name. They didn't put him in the stand. Well, he is not on the Commonwealth's witness list, but the defense snuck in a little comment that they reserve the right. So we're going to take a look at that in our next episode. I wonder if Norfolk County, Massachusetts, isn't the best county for this trial to go forward in, because of the Karen Reed case, there are a lot of skeptics about the judicial system. There are a lot of skeptics about law enforcement.
Yeah.
There are a lot of skeptics about the Norfolk County District Attorney's Office. I mean, we see it in our comment section, and I get chided because I say, "Come on, let's not attack the entire judicial system in Massachusetts, the United States." There was something rotten that went on in the Norfolk County District Attorney's Office, and so I'm wondering if the true skepticism about what happened in the Karen Reed case might make potential jurors very skeptical of anything that law enforcement says.
Yes, that's a possibility. Unfortunately, it's a possibility. And with everything that's gone on and Proctor being involved in this case, the Walsh case, I'm sure people are going to be skeptical.
I don't know if you remember, the very last day of the Karen Reed trial was June 18th of 2025. There was a massive crowd outside the courthouse, and the cheering was as loud as you've ever heard at a football game or at a World Series game. That was the extent of the massive joy from the Karen Reed supporters for the last 2 years plus. Often you'll be driving on an interstate and the Free Karen Reed people are up there, with their banners, and that was very present in Norfolk County. And so with all of that, with the Free Karen Reed movement, which continues even though she's free, we still see a lot of social media. We still see a lot of people commenting about it. We still see a lot of publicity. Aiden Kearney is very active. He is doing his YouTubes several times a week now, if not every day at the bus stop, and people are watching. So that's my first closing thought, is that Norfolk County might not be such a bad county to try the case in after all. I don't know. What do you think about that?
I think that Norfolk County is probably the best county in Massachusetts to try this case. I don't think if changing the venue would make a difference.
No.
And, going back to what I was telling you about the coverage here in California about the Walsh case, it might be that I was more interested in the Idaho 4 than the Brian Walshe case, and maybe I focused more on Idaho 4 than the Walsh case, because I'm trying to think back, and I just remember being fascinated with the Idaho 4. So I kind of modify my thoughts on the media coverage here in California. So my closing thoughts are, yes, I think Norfolk County is just as good as any other county in Massachusetts.
My other closing thought is this. You and I both covered, separately probably, but we both covered the change of venue hearing in the Brian Kohlberger Idaho 4 case. And that change of venue motion was argued, and it took all day, I remember, because I was doing some lives then, not a lot, and I didn't like doing them. I still don't like doing them. That's neither here nor there. But I figured it was going to be a quick hearing, and it started mid-afternoon our time here on the East Coast. And I thought, okay, I'll do a live. I'll be home in time to have dinner and walk the dog. Oh my gosh, that hearing went on and on and on. There were 5 experts. Remember that? There were 5 experts.
Yeah.
And so the experts were not only direct examined by the Kohlberger team, but then they were all cross-examined by the state of Idaho. So
Right.
and it went on. I actually learned a lot. From the one expert that was talking about their examination of what was in the media coverage and how many people, what were the demographics, who was watching the media coverage and how did it affect them. And so having been a media student, my undergraduate degree is in mass media, and having a lifelong interest in what's behind media, what makes it up, how to communicate effectively, there's a lot more in it than a lot of people think. And in any event, having an undergraduate degree in media, I learned a lot from watching that, and it was very substantive, it was very deep, it was very broad. Whereas this was, and no disparagement to the attorneys, I don't mean that at all, I'm just doing a comparison. This motion was well written, but it was pretty much based on, we're going to submit some media clips, and it based on the law. And so I am wondering, and I don't know the answer to this, and maybe down below they can tell us, had Brian Walsh's attorneys done the same thing and brought 5 experts in to support their change of venue motion, would there have been a difference? I don't know.
That's a good question. I know Ann Taylor went all out, and that kind of also makes me think there was more publicity on the Idaho 4 than the Brian Walshe case because of the massive amount of information that was presented in the motion to change venue in the Idaho 4 case versus the Brian Walshe case. She had experts talking, detailed, they had PowerPoints, and that was when the prosecutor accused one of the experts of asking information that was false, asking about information that wasn't true in terms of stalking. Remember that?
Right. I do.
Yeah.
Clearly.
Yeah. I guess Norfolk County, I don't think it's going to make a difference in that case, in the Walsh case where it's tried.
No, I don't either. All right. So I said in the beginning of the episode there were a lot of other issues, and there are a lot of other issues. And so please join us for our next episode, in which we're going to do just a little bit of a preview of what's to come in the trial, and what are the issues, and will the same law enforcement officers we're going to see on the pretrial memo, will they hurt the case? So before we go, we have our request by Lucky and Hank and Judge Cannoni for you to please subscribe.
You pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
And
All
there
right.
you go.
We've gotten a lot of feedback about that particular little public service announcement, and a lot of people like it. In the last couple of weeks, I actually had a couple of people say, well, we subscribed because we saw that, and we appreciate the fact that you don't advertise. I've been approached by several different potential sponsors at this point, and I said, thank you, bye-bye. We don't run ads on our podcast, and we don't sell, aprons or coffee mugs or any of that stuff. So all we ask is that you go down to the bottom there and subscribe. And, in the comments section, I just always ask people to keep it as high as you can. This is a legal true crime channel. We don't go down in the tunnels. And for those of you who've excoriated me for that comment, give us some facts, give us some law. And if somebody says something you don't like in the comment section, that's nice. Don't call them a name, but tell us why. So with that. Yeah.
We also were going to say a little something about our mutual friend, Tommy Jude.
Oh, thank you for reminding me. I'm sorry. Yeah, Tommy. Oh, poor Tommy. Passed away.
It's a hard thing to talk about, but I know we were both on his show at some certain points. And I know Cyree was even on his show.
Yeah.
One of the experts in the Koberger case. And it's very unfortunate, and I don't like to talk about it. But we thought we'd just say rest in peace, Tommy Jude.
I identified with Tommy because he was a musician in another life. He was a musician, and I've dabbled. I used to play bass in a band, and I've taken guitar lessons my whole life. I still can't play it very well, but I remember sometimes off screen we would talk about music, and so I really, if you don't know about Tommy's past, it's all, I'm sure, still posted on there. Tommy was really gracious. We had an issue one time. And who's the author that wrote that book about?
Howard Blum.
Howard Blum. And I did an episode where I interviewed Howard Blum, and my commenters just excoriated me. And Tommy Jude and I went back and forth on it and disagreed. But you know what? He's a scholar and a gentleman, and only took a couple of weeks before we patched it up and we went forward. And I always respected him for that, because there's people out there that hold a grudge. I mean, there are people out there that you have a disagreement with, and that goes to the bottom of their mind, the bottom of their very being. And Tommy and I, within weeks, we buried the hatchet, and we collaborated several times after that. And he would actually call me and say, when do you want to collaborate? And one time we did an episode which I labeled Stump Attorney Myers, because he had said, Attorney Andrew Myers is going to be on my... I'm not doing that very well. Attorney Andrew Myers is... I forget it. I'll keep my day job. I'm not very good at impressions, but Tommy had notified his people, weeks in advance that I was going to be on his episode. And so they had good questions. A couple of them did stump me. They asked some fact questions that I wasn't able to answer. So I labeled that, Stump Attorney Myers. And it was fun. It was always fun talking to him. He was an interesting guy. If he didn't know something, he would admit it. Some of my commenters gave me a hard time. Tommy is a conspiracy theorist. Well, we all had questions. We all had questions about the Koberger case. So, but I ramble
he was always respectful to me, and he said, I know you don't really like to speculate too much, but, and then he would go on, and I would say, if it's just your opinion, it's your opinion, but, to be careful about not to, cause, or say things that were not true. So he respected that about me, and I respected that about him, and oh well.
He was an entertaining guy.
Yes,
he was Okay. On that note, rest in peace, Tommy Jude. You were a great creator and a great person, too. Be nice, everyone. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
Rock and roll.